Thanks, Jeremy. All right. Well, I want to start things off by welcoming everyone to this month's teachingamericanhistory.org webinar sponsored by the Ashbrook Center at Ashland University. TAH.org is the leading online resource for documents-based study of American history, government, and civics for teachers, students, and citizens alike. Greetings, my name is Jason Stevens. I am a visiting assistant professor at Ashland University in history and political science. The theme of this year's webinar is landmark Supreme Court cases. And for those just joining us for the first time, the point of these webinars is to pull together in one place thoughtful scholars and have a serious conversation about 10 historically important Supreme Court cases. We encourage all of you joining us today to participate in that conversation by submitting questions via the chat box, and we'll try to get to as many of those as we can throughout the next hour and 10 minutes or so. In the next week, you'll receive an email with a link to request a certificate of participation, as well as a link to the archived video and audio from today's program. And to help us, I guess, begin to think about the topics of this year's webinars, we are drawing speeches, letters, and writings from the Ashbrook Center's extensive document database available at, again, TAH.org. And the subject of today's program is the landmark Supreme Court case Gideon v. Wainwright, decided in 1963. And to help us discuss this case, to have a conversation about it, we have joining us today John Deenan of Wake Forest University and Eric Sands of Berry College. I welcome both of you gentlemen to the program this morning. Thank you so much for joining us.
Good to be here.
Yes, thank you.
Great. Well, I guess to start things off, let me just put out there a rather broad question about the historical circumstances of the case at hand, Gideon v. Wainwright. What were the circumstances of the case? What was the background that led to this case before the Supreme Court?
Sure, I'm glad to start that off. And let's start with the named participants in the case, Gideon v. Wainwright. Gideon refers to Clarence Earl Gideon. He had been convicted in a Florida state court proceeding for breaking and entering a pool hall with intent to burglarize it. He had, at the time of his going before the court, he had requested to have counsel assist him, and he was denied counsel by the Florida court. He was convicted, and this was a felony offense, and he was convicted and sentenced to 5 years in prison for that. So that's Clarence Earl Gideon. Louis Wainwright is the other named participant. There was actually an earlier named participant, but he job changed. He's the head of the Florida Prisons Division. So Clarence Earl Gideon is bringing suit against Louis Wainwright. In this case, he's claiming, I was denied my right to counsel. And because the court in Florida did not give me counsel, when I asked for one, I said I was indigent and therefore too poor to afford one. And the court of Florida at that point said, there's no right for you to have a counsel appointed to you as a matter of right. You can retain counsel if you want to pay one, but under current U.S. Supreme Court doctrine, the U.S. Supreme Court has said that states are still free as of this time to decide for themselves the circumstances under which they provide counsel, except they have to provide counsel in capital cases. If someone was up for the death penalty, they would have had to do it. But other than that, it was up to the states. And so the case comes before the U.S. Supreme Court to see whether or not there's a warrant for changing U.S. Supreme Court doctrine and requiring states in all cases, or at least all felony cases, to provide counsel for a defendant.
Okay, very good. So at issue, the constitutional issue at stake in the case is the right to counsel as laid out in the Sixth Amendment. Is that right?
That's correct. And just to give a little more background here, the U.S. Supreme Court had said earlier that the Sixth Amendment, which up in through most of the 19th century and for parts of the 20th century, the Bill of Rights had only been held to apply against the federal government, that is, to restrict the federal government. And so the U.S. Supreme Court had decided in a 1938 case, they said, well, the Sixth Amendment right to counsel requires that in federal prosecutions, someone must have the right to counsel even if they're indigent. But they had not applied that to state proceedings. And that came up explicitly in the Betts v. Brady case in 1942, where the question there concerned, okay, so there's a federal right in federal proceedings to have a right to counsel in non-capital cases. But does that apply to state courts as well? And the U.S. Supreme Court in Betts v. Brady said that does not apply to state courts as well. State courts, you are still free to determine whether or not to provide counsel for indigent defendants. Some states were doing that. Some states did not do that. Florida is one of the states not doing that still by the early 1960s. And so Gideon was making the claim this should be a right under the Sixth Amendment to the U.S. Constitution that should apply not only in federal criminal cases, but in all state criminal cases.
I see. Very good. Very good. So the Betts v. Brady case, John, that you referenced from, what was 1942?
That's correct.
Right? So the Gideon v. Wainwright case ends up overturning that previous decision and applying through the 14th Amendment the Sixth Amendment's right to legal counsel to the states. Is that correct?
That's exactly right. This is one of a series of cases where the U.S. Supreme Court during the course of the 20th century would interpret an amendment, a part of the Bill of Rights, and say, well, this applies against the federal government. This applies in federal court proceedings. But they had not yet decided whether or not to apply this to state court proceedings. We had a similar case in regard to the Fourth Amendment, the search and seizure provision of the exclusionary rule, where in an earlier case in the 1940s, the Supreme Court said, well, the exclusionary rule must be applied, that is, evidence seized improperly must be excluded from federal trials, but they said we're not going to apply this against the states. And then they came back in 1961 in the case of Mapp v. Ohio and said, now we're going to apply this. We've already applied this, interpreted the Bill of Rights against the federal government. We're now going to apply it and incorporate it through the 14th Amendment against the states. So they would do, this is one of a series of decisions of this kind. And what's significant about this case is this applies the right to counsel in all felony cases, not only against the federal government, but against the state governments.
I see. Good. I want to try to bring Eric into the conversation. Eric, I wonder if you could tell us a little bit about the court's decision in Gideon v. Wainwright. John told us in a summary way what the ruling was, but can you tell us maybe how they got there, especially considering that this is a case that overturns previous court precedent as established back in 1942. What were some of the arguments of the court? And I believe this is a unanimous decision, right, announced by Justice Black. So there's no dissenting opinions. There's a few concurring opinions, as I understand it, filed as well. So could you speak, Eric, to the court's decision making in this case?
Yeah, well, Betts had turned out to be an extremely complicated case for the states. It certainly was the case. John's absolutely correct that they didn't apply the Sixth Amendment through the 14th Amendment to the states, but they did create something that came to be known as the special circumstances doctrine, which said that in the interest of fundamental fairness, certain types of defendants would need to be granted automatic right to counsel in order to receive a fair trial. And so they had applied that to people who, because of ignorance, they said feeble-mindedness, illiteracy, or things of that nature, would automatically need to get assistance of counsel in order to receive a fair trial. And this created just an absolute train wreck at the state level, because none of the state courts knew exactly what the special circumstances were. And so they applied this incredibly haphazardly. Some states like Florida and Pennsylvania, took a very, very strict, sort of construction of it and applied it to very, very few types of defendants. Other states applied it very broadly and even included indigent defendants in it as well. And when some of these cases made their way up to the Supreme Court oftentimes found that the states had erred in not giving counsel to these different types of defendants. So you can understand this. The states are kind of vexed because Betts seems to uphold the principle that criminal procedure is largely left in the hands of the states. And yet every time they seem to exercise that power, the court's turning around and telling them, well, no, you can't do that. And no, you've got to grant them counsel. So it has created this incredibly messy doctrine. And, the court in Betts seems to have been concerned, first and foremost with the principle of federalism. And preserving the idea that the states, have this kind of this power to be able to organize and structure their own criminal proceedings, and that the federal government doesn't really have the power to interfere with that. And yet, under Betts, that's exactly what the federal government was doing on a fairly regular basis through these appeals to the federal courts. So there was a huge need for clarification on what exactly Betts required and what the states needed to do in the way of providing for counsel for different types of defendants. So Gideon comes along at an opportune time, and Chief Justice Warren, who had been recently appointed to the court, he had actually told his clerks to look for a case that would allow them to re-examine Betts.
That's interesting.
And perhaps give a new, because you got to remember the court had undergone a huge overhaul since the Betts case had been decided. In fact, I think only 2 of the justices from the Betts decision were still on the court by the time Gideon v. Wainwright is actually heard. So we've got a lot of turnover, and Warren does this this kind of favor to Justice Black, who had dissented very vigorously in Betts, giving him the majority opinion and allowing that dissent to become the majority opinion in Gideon. But the court has really undergone a transformation in its thinking, transformation in its attitude about federalism and about civil rights and liberties. So it's not a huge surprise that the court sort of takes the turn that it does. There's almost a certain sense in which the court was, I don't want to say stacking the deck, but of all the lawyers that they could have picked to appoint to represent Gideon in the appeal, they go to Abe Fortas, future Supreme Court justice, and a guy who's already argued several cases before the Supreme Court. So they're really bringing in a big gun here to try to argue this case. And he's up against this assistant attorney general from the state of Florida who's been out of law school for about 3 years. His name is Bruce Jacob, and he's in way over his head. He's argued a few cases before the state Supreme Court, but he has no idea what arguing before the Supreme Court of the United States is like. He's so new at the practice of law that when he gets to Washington, he hasn't served long enough to get automatic granting to the Supreme Court bar. So he actually has to get a special accommodation for a one-time pass to basically argue a case before the court. And the experience was absolutely miserable. He said afterwards, we've lost the case. He knew it didn't go. He knew it didn't go well. Black had tended to stay away from, in the opinion, from the incorporation arguments that have been made by a number of members of the court, the idea that all of the Bill of Rights had been incorporated by the 14th Amendment as to apply to the states. He tended to stay away from this and instead took this sort of narrower view that the guarantees of the Bill of Rights are implicit in the concept of ordered liberty, and had therefore been brought within the 14th Amendment by a process of absorption and had thus been made applicable to the state proceedings. So this idea of very selective kind of incorporation of a particular amendment that's absolutely essential to our understanding of fundamental fairness in criminal proceedings.
Yeah, and Eric, I'm glad you bring that last point up about incorporation, because I notice here that we have a question from one of our participants who asked if you could comment on the legal reasoning as to why parts of the Bill of Rights did not apply to the states in light of the 14th Amendment, right? So why is the court sort of picking and choosing what parts of the Bill of Rights apply to the states through the 14th Amendment, and why some are favored and others not? Yeah, please. Yeah,
sure.
John.
This is a long-running debate on the court for much of the time, for the 1940s, 1950s, and 1960s. And the classic kind of positions on this were, one was of total incorporation of the Bill of Rights, of the first 8 amendments, to the states. And that was a position held by some. Then there was another position, and that was Justice Frankfurter, who had just left the bench by the time that Gideon is decided. And Frankfurter was more associated with the idea that, well, not every single one of the first 8 amendments of the Bill of Rights was incorporated, and therefore, let's say, applied to the states. That the ones that really were fundamental to due process or fundamental to liberty, where a violation of one of these would shock one's conscience, one might say, it's only those are the ones that were applied to the states through the 14th Amendment.
Yeah, that's the argument that you get from the Supreme Court in the Gideon case, is it not? That legal counsel is now a fundamental constitutional right in order to ensure a fair trial. Is that accurate?
And that is accurate, and that's why that language about fundamental does appear. I think it's helpful to kind of call attention to that, because in that sense, once it's been determined that a right is so fundamental to the concept of ordered liberty, to the idea of constitutional government, once that's been decided, then one would have to apply that against the states by the 14th Amendment. And that's what you see happen in this case. It's really, as Eric mentioned earlier, it's really a debate about federalism to a great degree. That is, if once something becomes applied to the states, that means federal government, federal officials, in this case, federal judges, are determining that something's no longer in the state determination. And so the more that you have a total incorporation doctrine, the more that you are in some ways overriding the states and their determinations. That's at heart of the debate. Just one final thing, I'll just close off on this for now. We are not at a case now where every single one of the Bill of Rights has been held to apply to state governments. The most recent one to do so was the Second Amendment, which was held just 6 years ago to also apply to the states and therefore be incorporated. But the Third Amendment, guarantee against quartering of soldiers, the right to a trial in civil cases, there are still some remaining aspects of the Bill of Rights that have not been formally incorporated and therefore not have been formally applied to the states. That's where we stand today in 2016.
Oh, that's very interesting. That's very interesting. Eric, did you want to add anything to that?
Well, yeah, just that, Abe Fortas, knew the court quite well and knew the personalities of the justices and their judicial philosophies. And he knew that incorporation argument was not a popular one on the court. There was a couple of justices that were sympathetic to it. Justice Douglas, for one, and in his concurrence, he wants to leave open the door to full incorporation of the Bill of Rights. But he very self-consciously stayed away from trying to make these incorporation arguments. Because he thought that would really turn the court against the overall thrust of what he was trying to argue. And so he limited this to saying there was something very specific about the Sixth Amendment that applied through the 14th that had become fundamental, that it would be unconscionable to not offer counsel to indigent defendants or to anybody who needed one. And that seemed to have been the strategy that paid off in oral arguments and through his brief, is that he found the court more comfortable to rest itself on those grounds than one of sort of a total incorporation.
Very good. And very interesting, by the way, very interesting. I wonder if we could maybe shift gears here just a bit. I'm interested in the original meaning of the Sixth Amendment as far as the substance or the content of American civil liberties go. Right, we knew that before the Gideon case that the right to legal counsel had been ensured in all capital cases. But now here in Gideon by 1963, the question is raised regarding criminal procedure as well, criminal cases as well. And since the court ends up ruling unanimously that the right to legal counsel is now a fundamental constitutional right in order to guarantee a fair trial, is it accurate to say that the court that the court's ruling here represents the framers' opinion on the substance of civil liberties? Does the court go back to the founding? Does it go back to any of the debates in the founding on this question as to the meaning and the substance of the Sixth Amendment? Is that a recourse that the court avails itself of, and does it get the founders right on this question, or does it in any way extend or go beyond perhaps what the founders had in mind as to the content of civil liberties?
I'll take a first stab at that. I suppose there's two ways that we would ask about how this compares with the views of the founders. One would be on the understanding of what's meant by the Sixth Amendment and the right to counsel. And here it's pretty clear that we've seen a significant evolution from the founding period to the 1960s in what the particular question is. At the time of the founding, the question is when the right to counsel was inserted in the Sixth Amendment, that was because under previous common law, the defendant was not allowed to, in some cases, or was prevented from obtaining counsel in his own defense in these cases. And so there, the idea was, let's ensure that if someone wants to obtain counsel and be defended by counsel, that they would have the ability to do so. So that was the fundamental concern of the founders. So the best way we could talk about that, the relationship between that question in 1787 and 1789 and the question at stake in 1963 is fundamentally different questions. That is, there's no disagreement by 1963 that certainly if you want to obtain counsel and have somebody represent you, that won't be denied to you. But now an entirely different question, one might say, has been asked is, suppose you're too poor to obtain counsel, must counsel be afforded for you? And so really just a different question that's come up here. The one other way that this could be raised, though, is in what is the relationship between the U.S. Supreme Court and the federal officials and the decision about whether state courts or state governments should be able to make decisions about counsel. And there, we'd have to look at the 14th Amendment as a fundamental break between the time of the founding period in the 1780s and the 1963, because there the 14th Amendment had said this relationship between the federal government and state governments has at least changed in certain respects. How dramatically it's changed, that's up for debate, but at least it's changed in certain respects so that matters that were previously understood to be entirely under the control of states are now under the supervision of the federal government. That one could have a discussion about whether or not the founders in the 1780s could have entirely foreseen how many decisions that were in state hands at that point would now be under federal supervision by the 14th Amendment and then by the 1960s.
Yeah, part of what you just said there is very striking. Right, we're talking about legal counsel here that is going to be provided, not right in cases that had been established earlier than Gideon, for example. Right, if the person at suit was too ignorant in order to defend himself. But now we're talking about right, if the person involved is too poor to afford legal counsel on his own. And since the court rules that legal counsel in criminal cases here is a fundamental right, does that mean that this is that the right to counsel is a fundamental right that can only be enjoyed if government is willing to pay for it? Does this mean that in order to enjoy this fundamental right, government's going to have to pay for it? Is that right? Is that an accurate way of looking at this, or
the court
or not?
I mean, the court in Gideon that left a lot of questions unanswered, and one of them was certainly how we're going to pay for this apparatus of guaranteeing everyone right to counsel. And the lead on this is really taken by the states. Some of the states start legal aid societies. Some of them, initially start trying to provide by simply, appointing attorneys from the community to represent indigent defendants. And then some states really started pushing in the direction of creating public defenders' offices. where you're talking about, the public essentially funding, attorneys for those that can't afford them. But the court didn't give any direction on, the practical question of how we're going to pay for all of this, how, the institutional form that this was going to take. They seemed to take it for granted that the states could figure it out. and in fairness, and I want to say, more than 30 states had already passed laws requiring indigent defendants to have a right to counsel. So the court was on somewhat strong ground in sort of looking at the condition of things and saying, oh, the overwhelming majority of states have figured out how to do this successfully. And, it doesn't appear to be breaking the bank. It doesn't appear to be taxing the legal system. In fact, if anything, the argument that Abe Fortas made in the oral arguments is this would probably cut down on the number of appeals that we would end up having, because defendants would end up getting fairer trials, more just outcomes at the trial court level. And we wouldn't be dealing as much in the murk of appeals courts and, having to appeal, all of these issues raised from not being able to put up an adequate defense.
Could I jump in and just pick up from that point as well? We've been talking and focusing, really, I think, on federalism as one of the chief issues that's at stake here. What's left to states to decide and what's left to the federal government to decide in terms of requiring uniformity. As Eric pointed out, the vast majority of states had already decided prior to Gideon that that indigent defendants must be provided with counsel in non-capital cases as well. So we just had a few outliers here. But the interesting question that came up here on the court was, what is more respectful to federalism and to states? Is it to have this special circumstances doctrine that Eric wrote, where, well, you have to provide counsel for indigent and for people in certain special circumstances, but others not? Some people said actually to have that Betts v. Brady doctrine of special circumstances in place was actually not respectful to the states and not respectful to federalism, because it always required, as Eric was just getting into, this second guessing of what states had done. And so states could never, and state courts could never quite be sure, is this a special circumstance in the eye of the Supreme Court or is it not? And so some of the justices who supported the decision in Gideon v. Wainwright did so in part because they said, this is actually, we're respecting the states. We're not going to put in this bind anymore of having to guess what will happen once a case comes up to us and whether we'll agree with the special circumstances. Other kind of judges, though, took a little bit different position in some litigants, and they say, well, in the end, though, that is not respectful to federalism to have this blanket rule that you're going to impose us on a Gideon, because now you're telling us once and for all, we must do this and we must pay for it. So fascinating discussion here about what's more respectful to federalism and what's less respectful to federalism.
Yeah, please, Eric, jump in here.
Well, I was just going to pick up because I saw one of the questions and the queue there was asking us about how to relate this to judicial activism on the Warren Court. I believe that was the phrasing of one of the questions that's been posed to us. And this would fit in here, as Eric was getting into. Most of these decisions that come up in the Warren Court, particularly in the 1960s, Mapp v. Ohio, that applies the exclusionary rule and the search and seizure to all to against the states. Gideon v. Wainwright, as we're discussing here. Still other cases as well. The Miranda v. Arizona in regard to self-incrimination rights. In each of these cases, that what you had going on is you had states differing among themselves about what should be the proper interpretation of this. But most states by this point had already decided, okay, counsel must be provided for indigent defendants in capital cases. A lot of states had already decided to apply this exclusionary rule in interpretation of the search and seizure clause. The main effect of the Warren Court's decisions was to bring some outliers into line with the rest of the country. That is, you'd already had states that were already doing what the U.S. Supreme Court was telling them they must do in their opinion. But in this case, my understanding is that there are only 5 state courts that had not already done what the court was required to do in Gideon. And so when we talk about it that way, the court was essentially, let's bring some uniformity in line. There are some people who disagree with us, but the vast majority of states are already on board. It's telling when you look at the Gideon v. Wainwright, you have two sets of amicus briefs. There's others as well. One is from a set of states that say, please allow us to continue to have discretion. They're siding with Florida. But there's only two other states that are agreeing with Florida on this. And then there's another amicus brief that's saying, actually telling the Supreme Court, we actually disagree with what Florida is doing here. We want you to order that the states should have to provide this to counsel and to indigent defendants. That brief had 23 states joined on it. So in that case, that is, you had nearly half of the states asking the U.S. Supreme Court to hand down a decision requiring that the states do this. And you had a very small number of states siding with Florida saying, allow us to keep having discretion. That's fascinating to take note of where we already were by 1963.
Yeah, and you can kind of imagine, I mean, Bruce Jacob, the attorney for Florida in this case, was devastated by that. I mean, he thought he had hit on a great strategy for the case by sending a letter to all 50 state attorney generals. And he had asked them to sign on to Florida's brief in the case. And he was thinking, yeah, the states are going to support Florida on this. They don't want the federal government intervening. They want to keep control over their state criminal procedures and stuff. And he was absolutely dumbfounded when 22 of the states turned around and filed their own amicus brief saying, yeah, overturn bets. Let's get the right to counsel recognized at the state level. And as you said, he could only get 3 states on board with his brief, and he was just dumbstruck by this, and really showed you that the states in many respects really didn't know what other states were doing and what other states' opinions were on this issue, because he had no clue that brief was coming, and it shocked him. And clearly that brief made a big impression on the court, because Black concludes his opinion by saying 22 states think this is a bad idea. We agree with them. That's clearly leaving a mark on how the court is thinking about this.
And what happened, just for clarification's sake here, what happened to Gideon following the Supreme Court's ruling? Because I believe it's fairly well known that he ends up getting the case before the Supreme Court, right, by sort of from his prison cell writing out, right, hand and paper, writing out his claim to the Supreme Court. But what happens afterwards? Once the court rules unanimously in his favor, he's not immediately freed, correct? All that happens to Gideon is that he gets a new trial. Is that right?
Yeah, he gets a new trial, and this was one of the questions the court had left unanswered. So when Bruce Jacob had filed his brief before the court and during oral arguments, he said, look, if you guys are willing to overturn bets, if that's what you're going to do, so be it. But please, he says, apply the decision prospectively, not retroactively. Because if you apply it retroactively, we're looking at hundreds, if not thousands, of inmates that we're going to have to set free and grant new trials. And that's going to create a huge headache for us. This is going to be a disaster. So please apply it prospectively. Well, the court declined to apply it prospectively, but they also didn't entirely come right out and say it was being applied retroactively either. They kind of left that open. So it was back to the states again to kind of decide how the decision ought to be applied. And the state of Florida decided that the decision needed to be applied retroactively. So Gideon was actually released and was granted a new trial. And because it was him, the district attorney himself was prosecuting the case against him. They really wanted to convict him and put him back into prison. Gideon was actually granted legal counsel. It was volunteer from the ACLU. The 2 attorneys traveled all the way to where Gideon lived and offered to represent him, and Gideon said, no, I want a local attorney. I don't want you guys representing me. And these were 2 like highly qualified, really high powered attorneys, and Gideon was like, no, I don't want you, and I don't want you interfering with my ability to plead, because I want to plead myself in the case. So it was kind of fascinating. Here's the guy who has fought like hell to get the right to counsel, but now he's fighting to be able to maintain control over his own defense, and make decisions about how his defense is going to be applied and what strategies they're going to follow. So he ends up, the judge says, okay, if these guys aren't, amenable to you, who do you want? And so he names somebody, the guy gets appointed to the case, and they retry everything, and he ends up getting acquitted, of course. But in a way, the trial sort of demonstrated the wisdom of what the Supreme Court was talking about. Is that Gideon, of course, had tried to try the case himself, having no legal knowledge, no legal experience, and he got himself convicted. He gets a lawyer, and the lawyer is able to argue things that Gideon never thought about, had never really, imagined, and the lawyer ends up pointing all of the fingers at another potential suspect, and the jury ends up acquitting him.
One other thing to pick up from there is so this decision applied to all, it was understood as applying really to felony cases or cases involving a serious prison term would be the idea. But left unclear, left for later determination is what would happen with situations of misdemeanor crimes or others. And so it's only later, through later cases that would come up for the U.S. Supreme Court, the U.S. Supreme Court would have a decision to offer other decisions and applying this decision, and that is the right to counsel for indigent defendants, even farther and more expansively in terms of the cases that would be covered. So it really is, this is a crucial case, but it's a case that comes with even more determinations afterwards, and in that process. Not only do they have to decide, that was one of a number of cases that would have to be decided later, even following from this case.
And John, is it one of those cases that you point to, early 2000s, 2002, I think, Alabama v. Shelton? Is that right, where the court rules that the decision in Gideon doesn't apply to all criminal cases, but only to those where imprisonment is a possible punishment, right? So if it's a criminal case where prison is off the table, legal counsel does not apply. The Supreme Court rules later on in the early 21st century. Am I getting that right?
Eric may be more up on that particular case. I would want to steer clear. I just I'm not familiar with that particular case in that sense. But the general principle is the key one there, is that just as in Gideon, they'd already determined in Powell v. Alabama back in the 1930s that the right to counsel has to apply in state proceedings in capital cases. And then in Betts, they said, well, right to counsel should apply in felony cases where there's special circumstances, but not more broadly than that. Then the next progression is Gideon, as we're talking about today. Well, it applies not only in all capital cases, not only in felony cases where special circumstances apply, but in all felony cases, it's generally the understanding in that sense. And later determinations would expand that even further, but not to every single case you're suggesting.
Is another case that might come onto the court's radar in later years because of Gideon, the Miranda v. Arizona case from 1966? Yeah. Is that the legal result, or where the court is heading from Gideon?
Well, at least in one way, and that is the 1960s. If we think of cases in which the U.S. Supreme Court is faced, do these various provisions, particular provisions of the Bill of Rights, do they apply to states? And we have a certain understanding of what they say in regard to how federal prosecutions must run, but what is the requirement for states? And one key trilogy there is, not the only ones, but Mapp v. Ohio saying the search and seizure clause must apply. Then we get to Gideon v. Wainwright, and they say not search and seizure has already been held to apply against the states. Now right to counsel for felony cases now applies to the states. And then we get to Miranda v. Arizona and say the right to self-incrimination and certain requirements of how you must treat people in regards to questioning. That understanding of the Bill of Rights also applies against the states. So I think it's very helpful in some ways in teaching purposes or so to kind of almost group these cases as illustrative of a type of question that was just coming before the court in the 1960s on a regular basis. How about this provision of the Bill of Rights? Should this be applied to the states in a uniform fashion? Yes, the court kept checking off in a number of cases. Miranda, Gideon, Mapp as some of the leading ones.
So the historical impact then of Gideon is mostly in regards to the question that we've been debating all along, is this federalism. Is that right?
I think so. I let Eric take a crack at this too, but really at heart, and I see some of the questions that are coming in from some of the participants, and I go back to one of the questions about what freedom was left to states in this regard. One of the questions asked about that, what kind of that has federalism components. Another questioner referred to kind of activism of the Warren Court was the phrasing that was used there in the question. Really, the key question here in a lot of these cases that come before the U.S. Supreme Court is the question of federalism. In what areas must state courts be brought under supervision of the U.S. Supreme Court and U.S. Supreme Court interpretation of the U.S. Constitution? And in what areas do state governments and state courts and state officials still have wide discretion to make their own determinations? Insofar as these, as provisions of the Bill of Rights are not incorporated by the 14th Amendment against the states, that allows state governments to have complete discretion, and not complete discretion, but discretion in this particular area to go things their way. As Florida, up until this point, they've been saying we're not necessarily providing counsel for indigent defendants as a matter of course. Other states had been saying, well, we will do that. That had been the state of affairs, a state of diversity, a state of some states would experiment one way, some states would experiment another way. What's at the heart of a number of these cases that come before the Supreme Court in the 1960s, Mapp, Gideon, Miranda, is the question of to what extent should uniformity be in order? To what extent should we take away some of the discretion that states have been having about how to run things? And to what extent should be this a minimum threshold understandings imposed by the U.S. Supreme Court based on understandings of the U.S. Constitution? That was really a central issue in these cases, the question of federalism.
And I see another question here from Julie. She asked this, and I don't know, maybe Eric, you can help us out on this question. In the segregated South, Julie asks, was this applied? That is, this ruling in the Gideon case, with some semblance of equality to both blacks and whites. As a result, did blacks receive trials that treated them more fairly? Was this the result that you saw in the segregated South post Gideon, a greater likelihood of African Americans receiving fair and impartial trials in the South?
Well, one of the things I'd say about that is there's a lot of different elements that go into a fair and impartial trial that are independent of having the right to counsel. And to my knowledge, at least, what I've looked into, black defendants that were, of course, being tried for felonies were granted right to counsel, but that doesn't mean they were in front of impartial juries. That doesn't mean that they were in front of impartial judges. So even with counsel, that did not necessarily mean that they were getting the full benefits of a fair and impartial courtroom. In front of an all-white jury, getting a fair trial was still a difficult undertaking for a lot of black defendants in the segregated South. But this was certainly a step in the direction of getting a perhaps more fair system in place. But there was obviously still a very, very long way to go before the South was reformed in its criminal justice system.
Yeah, I think you're exactly right about that, Eric. I think you're exactly right about that. So besides legal counsel, there are a whole other host of factors that go into a fair trial. And many of those, as you remark, right, were lacking in certain parts of the segregated South.
Yeah.
So Gideon doesn't end up doing much then in order to advance justice for African Americans in the South.
Well, I mean, it did more than what's being done before, but certainly doesn't go near as far as needed to achieve the goal of a fully fair trial in a lot of those places.
Hmm. Were there any points brought up in the various concurring opinions? I believe, correct me, guys, if I'm wrong about this, but I think there were 3 concurring opinions filed. Were any of those of particular interest to you, that right, maybe they decided on the case in a different way than Black had articulated in his opinion? We know there were no dissenting opinions, but is there anything that is worth taking away from those separate concurring opinions that are filed?
Well, some of these of the 3 concurrences, as you rightly note, were more discussing, by my reading, they were engaging with this question about what are we doing when we apply certain provisions of the Bill of Rights against states and against state courts. And this was, in this sense, this came in the midst of a long-running discussion where Justice Black and the recently stepped off the bench Justice Frankfurter had been going back and forth on under what circumstances should we apply Bill of Rights to the states and state courts, and there have been different theories proposed. And so I took several of the concurring opinions to be interjections in this debate. That is, they recognize we have just applied, rightfully so, all the justices agree, we have just applied the right to counsel in felony cases to the states. But what does that say about going forward? In other words, that is, are we going to apply all of the Bill of Rights to the states, or what they were kind of teasing out here? What goes forward? What are the implications from this? And the one other thing I would say, so that's part of the interjection, is what have we just done, and what does this mean for going forward in other cases in regard to other provisions of the Bill of Rights? But Justice Harlan is probably the one who had the most extensive concurrence. His is the final concurrence. And he takes issue with Justice Black and his majority opinion and said, well, we needed to overturn Betts v. Brady. That was really a break from the past. And he had said that in his opinion, in his majority opinion in Gideon. He said, well, that was, somehow we went wrong in issuing Betts v. Brady, and now we're kind of going back on course. And Justice Harlan took a number of paragraphs to take issue with this. He said in some ways that he starts off as a concurring. He says, I agree that Betts v. Brady should be overruled, but considered entitled to more respectful burial that has been accorded, at least on the part of those who were not on the court when the case was decided. And so he goes on to say, look, here's what the court probably thought it was doing in Betts v. Brady. It was not so much a break from the past, but that was just the general understanding at that point that state courts and state officials still had determinations to make in this area. And so he was essentially kind of going back over past history. I might just take that opportunity, without going too much longer with this answer, to say one of the things that I do for teaching purposes, or one of the opportunities to engage with Gideon v. Wainwright, has so rich of a case. You can engage with it on the way how the case came before the court, the informa pauperis petition, which we could talk more about here in a few more minutes if there was interest. That's one angle into it. Here we had this handwritten petition that comes before the U.S. Supreme Court. That's a fascinating in its own right for teaching purposes and just for scholarly purposes. Then there's second, there is the circumstance of how the case was argued. As Eric has already mentioned, Abe Fortas, who several years later would get on the U.S. Supreme Court, and here he's picked to kind of argue this case, and in a case that's certain to be overruled. But one other area, and this is good, is the idea of how the U.S. Supreme Court changes its mind over time. And this is very rich in that. That is, just 21 years earlier, the U.S. Supreme Court had issued a different interpretation of the Sixth Amendment. And here we are 21 years later, and the U.S. Supreme Court is overturning a case. It's overturning its opinion. This has all kinds of implications. We could talk about it, why it happened in this case, but also has implications of what other cases did the U.S. Supreme Court change its mind, and when does the U.S. Supreme Court change its mind? Clearly, as Eric has already noted, that part of it is a change in the membership of the court. That is, only Justice Black and Douglas were on the court in Betts in 1942 and were still on the court in Gideon in 1963. So we had a whole new group of judges coming on and a whole set of justices that were leaving. And so that's part of how the U.S. Supreme Court changes its mind. But part of it's just societal evolution. That is, of a generally evolving understanding of what it means to have a fundamentally fair trial. That probably accounts for some of how the court changes its mind. So that's interesting as well. And so I'd take, to go back to your question, what are the concurring justices doing? They're in part going back over and saying, well, we've just changed our mind as a court. Well, why did we do that? And what are we saying by changing our mind?
Yeah, please, Eric, go ahead.
I was going to say, just in terms of the concurrences, I also thought Justice Douglas stood out for me. He's
one of the guys who was also there for Betts v. Brady, right?
Yeah.
Okay.
And so he's sitting here, making the case. Okay, this was a great baby step forward, but I'd like to see us go so much further. He's the one embracing the full incorporation doctrine, and he says what he hates to see the occasion sort of pass without re-arguing the proposition that the 14th Amendment incorporates the full Bill of Rights. He says this is a ripe opportunity to be doing this, and we're letting it go by focusing narrowly just on the Sixth Amendment. And so he actually says in the concurrence, unfortunately, he says, this approach or this way of looking at things has never commanded a court, yet happily all constitutional questions are always open. And what we do today does not foreclose the matter. So, looking forward for him to the idea that, perhaps this is a harbinger of things to come. And, maybe one of these cases, the court can just go ahead and embrace the idea that the full totality of the Bill of Rights should be incorporated into the 14th Amendment. And we can just roll forward there. He obviously doesn't get his wish, but it's interesting that perspective is on the court, and we wonder how many other justices might be sympathetic in some respect to that viewpoint.
Yeah, fascinating conversation here. I want to jump in here with a question from Stacey Moses along these same lines about the incorporation of the 14th Amendment. Stacey asks, let me scroll up here to make sure I get it right. So when was the 14th Amendment first regularly included in appeals to the Supreme Court? It seems that almost every appeal includes a reference to the 14th Amendment, and were Mapp and Miranda filed as a violation of the 14th Amendment.
Yeah, I mean, this is part of a broader discussion that basically took place throughout the course of the 1900s and still continues in the 2000s. And that is essentially, when the 14th Amendment was ratified, was it intended to apply all of the provisions of the Bill of Rights to the states? Was it meant to apply just some of them? And you start to see in 1925 in the Gitlow case, and the U.S. Supreme Court says, well, the free speech clause, that is applied to the 14th Amendment to the states. And then you start getting other cases come up, and of course the in 1960s, the cases that we've been just talking about, the Mapp case in 1961, the Gideon case in 63, Miranda later on in the decade. Each of those, by this point in time, and to get to the question here, yes, the litigants in the cases, the 14th Amendment and the idea of incorporating the various provisions of the Bill of Rights against the states through the 14th Amendment, that is raised repeatedly. And so they keep saying, look, you've incorporated and therefore applied these other provisions of the Bill of Rights to the states. This is the next one that you should do. And now how about double jeopardy? Now how about this? And eventually we would get to 2010. And how about the Second Amendment guarantee of the right to keep and bear arms? Shouldn't that also be applied to the states? So by the mid-1900s, I guess if I could put it this way, this becomes to be a frequent argument being brought up by litigants saying, this is a provision in our U.S. Bill of Rights, and you shouldn't that apply to state courts and state officials as well? In a number of cases, U.S. Supreme Court justices are agreeing with that argument and saying yes.
So it sounds like the 14th Amendment wasn't applied right away. That is, right after the Civil War. It takes another generation, really, for these arguments to come forward to the court, where aspects of the Bill of Rights are now being applied to the states by virtue of the 14th Amendment's Equal Protection Clause and Due Process of Law Clause. But that is something that the nation waits for.
Or at least was brought up in some early cases in the 1870s, in various cases, whether it be the slaughterhouse cases or other cases, in which the question was raised is, what did we just do here with this 14th Amendment? What exactly? We understand that we did certain things with this. We understand, but how far did we go? And essentially, the U.S. Supreme Court, in various cases, and several cases in the early 1870s, essentially says we did not, though, do much more than hold that the Equal Protection Clause now prevents certain unequal treatment of African Americans and on the basis of race. But we are not, the Supreme Court says in those early cases, saying the Bill of Rights and various other provisions of the Bill of Rights now apply to the states. As you say, it would be several generations afterwards. It'd really be the early 1900s before those arguments start coming up again, and more important, start being accepted by the U.S. Supreme Court.
Is it too difficult to ask this question? The way that the 14th Amendment has been applied up to the present day, is this something that the framers of the 14th Amendment could have envisioned? Is this something that they may or may not have intended? Can we speak on that at all, or is that too difficult?
Well, I can jump in there and say no.
No. So not difficult at all. No.
I actually have a book somewhere here in the office that I usually keep on hand, and for some reason I don't have it right now. But it's the history of the debates over the 14th Amendment, and it's got all of the House and the Senate debates. And the book is about 2,800 pages long. And it's in about 4-point font, as it's copied out of the congressional record and stuff. There were no two people that knew what they were doing with the 14th Amendment. I think I actually have a lot of sympathy for Justice Warren in Brown v. Board of Education when he says, when you go back to the history of the 14th Amendment, you just find a mess, and it's. We can't really try to ascertain what the meaning of the 14th Amendment was when it was originally passed. We can only kind of decide what the 14th Amendment means for us today, in light of the full flourishing of education in America. Studying the history of the 14th Amendment is a nightmare, and you literally can't find more than 3 people at any given time who seem to be on the same page about what it applies to, what it's attempting to accomplish, how broad its scope is, whether it applies to the states, whether it just applies. It's an absolute quagmire. So it's, to me, not a real big surprise that the court initially interprets it very narrowly. And sort of says, okay, we're going to apply this in a very limited context because we're not really even sure what the 14th Amendment was attempting to do. And then later on kind of grows more comfortable, with the language of it and says, well, there might be some things that we feel like we can do that's good on behalf of society. But I have always had a hard time, from a teaching perspective, talking to students about what the intentions of the framers of the 14th Amendment were, because I don't think they shared a lot of common ground when it came to what they were trying to accomplish in the end.
Very interesting. John, did you want to add anything to that?
No, that sums things up for me as well. That is, a lot of effort has been spent. A lot of scholarly effort has naturally been spent looking at every single one of those pages of the debates that Eric just mentioned. And it is possible, and some scholars and some justices have gleaned from particular comments in those debates where a senator or a House of Representative member would say, well, here's what I intend to do by proposing this, or here's what I think is going to be done by if we pass the 14th Amendment as it is. Well, I think this will make all the first 8 amendments, this will make the states be obligated to abide by them. But so if one looks hard enough, one can certainly find some intent of some of the drafters to have done that. The challenge is we don't see that those type of statements by a number of other people in the debates, and we certainly don't see a broad consensus that that's what they intended to do. And so it becomes very challenging.
I see that we're quickly approaching the end of or the conclusion of our session. I want to give both of you an opportunity here as we begin to draw things to a close, to speak about the historical significance of the Gideon case, or any of those cases that we have referenced today. And also, if you could maybe point us in the direction of some additional resources, some additional material that might be helpful for us to understand some of the key concepts and arguments that we've been discussing here this morning. Eric, I'm especially interested to hear maybe a little bit more information about this book that you referenced on the original meaning of the 14th Amendment. But what other resources might the two of you recommend to us for further reading on these subjects?
Well, let me start by just the canonical text for any discussion of Gideon v. Wainwright begins with Anthony Lewis's book of Gideon's Trumpet, which tells the story in very rich fashion from the beginning of how the case came before the U.S. Supreme Court, how the U.S. Supreme Court came to ask for direct and oral arguments to be held on this, how the litigants and the lawyers approached this, both Abe Fortas from the one side and Bruce Jacob from the other side. The aftermath of the case tells exactly how the case was come before against in Florida Court afterwards, and how Gideon was eventually freed. So Gideon's Trumpet is just a leading source to companion for understanding this. They're certainly going to the cases themselves of Gideon and Betts. Two other things I would mention, though. One is it's possible, and this is available on various sites. One is the OYE site, OYEZ, where you can actually get the oral arguments from this case. And sometimes that's fascinating for teaching purposes, to be able to play snippets of the actual oral arguments as they came before the U.S. Supreme Court, or actually that in some cases, if you just want to have the written arguments of these cases. That's fascinating to bring them alive. And then the final thing, and this was, I know, available for the materials here in preparation for this webinar, is the actual petition that Gideon actually wrote up, this informa pauperis petition on this lined notepad from the Florida prison in which he was serving, in which he sets out, he's writing to the U.S. Supreme Court that say, here's why you should actually grant my case. And you see this, very clear handwriting. There's some sense of some engagement and grasping of legal terminology in this. Has to be signed off by someone from the prison to kind of sign off and that he does qualify to be submitting this petition. So those would be some of the teaching materials or the scholarly materials I would most highlight in terms of learning more about this case.
Yeah, I did manage to find the the book I was looking for. It's called the Reconstruction Amendment Debates, and it's a very thick volume. Legislative history and contemporary debates in Congress on the 13th, 14th, and 15th Amendments, published by the Virginia Commission on Constitutional Government. Editor is Alfred Avens. And they have the compilation of all the debates in Congress over the Reconstruction debates, and that includes, of course, the 14th Amendment. And an invaluable resource that I've come back to a number of times in doing research on various projects over the years. In terms of historical significance, I guess the one thing that I'd point out or just illustrate, and it's one of the things that I talk about a lot with my students when we discuss Gideon. It's the idea of the individual against the government. This notion that individuals are powerless against the power of the government, and that there's nothing that can be done when injustice has occurred, or you've been wrongly convicted or accused. And one of the things that's so neat about the story of Gideon is, the guy is kind of crazy, and he's not a real nice guy. He's got a long felony record. You could find a sexier defendant if you wanted to look for it and stuff. But the fact is, I mean, this guy from his jail cell, writes this petition to the Supreme Court, and it ends up getting selected, and goes on appeal, and ends up participating in a case that has profound impacts and changes in U.S. law. And all of that started with him sitting down and writing on a piece of paper. And there's something about that that's kind of awe-inspiring, that an individual can have that kind of influence, including one that had no real education, was functionally indigent, but not certainly highly educated. That he was able to do what he did, and that the system essentially allowed him to do what he did. I think is a testament to a lot of things that we sometimes grow kind of cynical about in American government. And there's something I've always found very hopeful about the story of Gideon and what he accomplished. Even though, as I said, I could probably pick a better defendant to get behind.
And John, do you agree with that as sort of that's the thought maybe we should take away from the Gideon case, as Eric has summarized it there? Or did you want to add anything to that?
No, I think that's certainly one of the leading ways to place the focus on. I'll just come back, as I've come back several times in the discussion, to the way that this could be pitched as a focus on federalism as well, and that is a relationship between the federal government and the state governments. And just to sum up, I guess, a point I've made, one of the challenges that we always face, and we face this now in the 2016 and other fashions, is in what areas should state governments be free to make their own decisions about how they try cases, and in what areas should the federal government be responsible for, should ensure uniformity. Now, we face this in a lot of different ways. We face this today, to take away from the criminal, the kind of case here, is should states be allowed to go their own way in regard to whether or not they legalize medical marijuana or recreational marijuana, or is uniformity required on this? How about in regard to voting? A number of states allow for people to register to vote and vote on the same day. The vast majority of states say no. If you're not registered to vote before you actually show up to the polls, you don't vote that day, and you register. There's all kinds of different ways. Just in the months since the 2016 elections, we've been struck by the degree to which states retain a significant degree of control, even over how they go about recounting votes cast in a federal election. And so one way that I pitch this case is it goes back to just a central question in American politics: is in what areas should state governments be free to make decisions their own way? In this case, when and in what circumstances to provide counsel for defendants? And in what areas should we expect certain uniformity and certain minimal standards, so that if one thing happens in one state, the same thing could be expected in the other state? That can also be brought out of the Gideon case.
Very good points from both of you. I think that is a nice way to sort of wrap up such an interesting and fascinating conversation this morning on not just the circumstances and the judicial proceedings of the Gideon case, but also its historical impact, its historical significance for today, which we continue to see up to the present moment. I know we're quickly running out of time, but I just noticed one last question popped up here. We don't need to, I think, answer this, but I think it speaks its own importance. Someone in the chat just referenced the North Carolina church shooting case from 2015, and the accused Dylan Roof. He is maintaining his right not to have legal counsel, to refuse legal counsel and represent himself. So sort of refusing to take the benefits that the Gideon case, in part at least, had provided into the modern day. So this is a case in more than one way, I think that is still with us. We still see sort of the reverberations of this 1963 case throughout history. Let's see. I see we are only have a few minutes left, so before bringing the matter to a close, I want to. Oh, it's Dylan's case is in South Carolina. Sorry. I wanted to thank both of our panelists here this morning, John Dean and Eric Sands. And in addition to that, I also want to thank our participants for some really great questions this morning on not just the Gideon case at hand, but the role of the Supreme Court in a constitutional republic. So thanks to everyone who participated, but again, our panelists especially, thank you for joining us. I do want to just say as a quick reminder here at the end of things that about the email that all of you will receive with a link for a certificate of participation in this morning's web seminar on historic Supreme Court cases. If you have enjoyed today's webinar, please consider taking an online graduate course through the Ashbrook Center, which are also offered as part of our MAG program. You can find more information about Ashbrook's online course offerings at teachingamericanhistory.org or TAH.org. You can help us spread the word about these programs by sharing the archive link, which you'll receive by email next week to your colleagues and on social media. And I believe that we'll also have up the recommended readings that our panelists had put forward for further review, for further study. If you're interested in pursuing some of these questions further and helping in making your classes better, our next Saturday webinar will be in early 2017. So it looks like this is our last one for 2016, but our next Saturday webinar will be January 7th on a case that we mentioned here today, Miranda v. Arizona. So on January 7th, we'll be discussing Miranda v. Arizona. And at that time, Jeff Sickinga of Ashland University and Stephen Tootle of the College of the Sequoias will be joining us to share their expertise on the matter. Once again, I want to offer a special thank you to John Dean of Wake Forest University and Eric Sands of Berry College and the Ashbrook Center at Ashland University. At this time, I think since I see we've reached our time limit, I will say thanks to everyone for joining us today. I hope you learned a lot. I know I did. This has been absolutely wonderful, a very enlightening experience. And I hope that we'll see many of you around with future Ashbrook events down the line. So thank you, everyone. Thank you for joining us.
Good to be here.